Okay, good morning, everyone. Thank you for joining us today for our weekly trade and tariff briefing. I'm Christine Rafikian, Senior Director of International Programs here at World Trade Center, Utah, and I have the pleasure of facilitating today's conversation. If you're here for the first time, this weekly webinar is intended to provide you with the latest information about trade and tariffs. You can view previous webinars on our YouTube channel and find updates to our tariff dashboard on our website, which we'll link in the chat for you. Today, we're excited to hear first from Ben Collender, Chief of Staff at World Trade Center Utah, about updates to the World Trade Center Utah tariff dashboard. We'll then welcome Tim Butler, shareholder, and Matt White, associate from Greenberg Traurig. It's all yours, Ben.
Thanks, Christine. Gonna share my screen. There we go. So first of all, thanks for being with us this week. Last week we had off. Next week we'll have off as well. It's that time of year where we have some blackout dates on our calendar. So appreciate everyone who could join today. If this is your first time joining us, this is our tariff dashboard. Many of you have seen it before, but we always like to call this out at the beginning, and also as well this link if you want to share this with somebody that you know in your network who would benefit from these briefings and the updates on all things tariffs, please feel free to share this. Going to go through first today and talk a little bit before we talk about tariffs about some of the deals taking place. We're just going to be very brief on this, but if you are doing business in either Uzbekistan or India, you just want to monitor some of the actions taking place. So the U.S. Trade Representative, Ambassador Jameson Greer, had done some travel earlier and saw a lot of positive news come out from both of these countries. So from Uzbekistan, you have an announcement here that talks about furthering our bilateral trade partnership and has some details there. And for India as well, just more of an expression of positive progress between the two countries. And I should also say World Trade Center Utah was present in the India visit as well. And so we were fortunate enough to take to be on the outskirts of it and involved in a lot of the conversations as well. So seeing a lot of positive progress on those two fronts. And so just a quick highlight for some of the deals section going on. And we're also hearing more and more chatter about the Japan $550 billion investment fund. And so if you're doing business in Japan, a lot of this is going to be debt focused. A lot of these deals are going to be huge in the $1 to $5 billion range. But if this is something in terms of looking at international partnerships at a large scale and it's something you're interested in, please reach out to World Trade Center Utah. We are happy to facilitate and see how to best incorporate or share information about that and what we know. And so we're going to get to the tariff dashboard now and all the latest news on tariffs that we see going on. First, we're going to touch on USMCA. We saw another joint statement following the June 15th to the 17th meetings that took place in Washington, D.C. with USTR and Mexican trade officials. This is turned into a bilateral negotiation with Mexico, while Canada is still, we're waiting for, more in-depth negotiations with them. But for Mexico, there's a lot of progress taking place. The next round of talks is going to be around July 20th in Mexico City. And so we continue to see positive progress on that front relating to Mexico. You did see before that we had an effective date of July 1st on the joint negotiations or timeline for that. We took that off because a lot of these are going to be ongoing now for the joint review. So anyway, we'll continue to monitor Canada, Mexico, USMCA, but for now, Mexico's making a lot of progress. Canada, we're waiting to see more details, and as they become available, we'll share them. We also saw 301 this week on Germany. So we saw an announcement from USTR on an initiation of Section 301s. And this is mainly in the pharmaceutical industry. And the accusation or the investigation, I should say, is more around Germany pricing their goods too low in Germany and then charging higher prices elsewhere, including the United States. So the 301 investigations we've gone through this before. They typically take 12 to 18 months. We anticipate much shorter timelines right now because the 301s and the 232s are going to be the primary legal tariff implementation mechanism for this administration and what we can see. And so we anticipate faster than that, but traditionally 12 to 18 months. This investigation was launched on the 18th, so that, puts us anywhere to next summer into next fall. At the latest, I would say, but in all reality, it could be this year or early next year when we start to see some of these tariffs take effect. So another one that we'll be tracking on our dashboard as further details become available. We did see we continuously track a lot of the legal actions that take place that affect everything from IEPA to 122s. Um, on this week's version, we have the 301. So this case has been sort of um, been kicked around since I believe it was 2023 about the legality of the 301 tariffs relating to China. This was something that made it all the way up to the Supreme Court. And basically, the Supreme Court denied without comment the plaintiff's petition. So this sort of refund litigation lays to rest in large part the 301. So if you were hinging hopes on the 301s not being a legal mechanism for implementing tariffs, this case seems to clarify that that is not going to be a hope that should be maintained. Uh, and the last item I have is actually, I'm going to stop sharing my screen because we don't need to share the dashboard on this, but just more or less talking through some of the um, high level dates and comment periods for folks to continue to track. So the 122 tariffs that are still in effect right now end on July 24th. So this is a temporary tariff, supposed to last 150 days unless Congress extends it. It's still in effect. We've heard murmurs here and there about 15%, but at this point, it's likely to stay 10% until the July 24th expiration. There's still some open comment taking place right now with the China Board of Trade that is until July 5th. So you'll want to make sure that's coming up here pretty quickly. If you have comments on the China Board of Trade, so this is seeking comment for if you have products that aren't a national security risk, and this is the 301 lists on China as well to consider in this bucket. If this should be tariff exempt because we can do business with China in this realm, you want to provide comment, share that in the public comment period so that so that USTR and these trade negotiations and with this trade council can consider that in terms of our bilateral trade relationship with China. We also have Brazil with open comment until July 15th. These are the 301, or sorry, until July 6th, I believe. No, that's forced labor. July 15th on Brazil, July 6th on forced labor. So, all to say, in the next few weeks, there's a lot of 301s that may impact your business, covering a wide range of company or countries and industries. And if you have a product affected by these 301 tariffs, your timeline is closing to provide comment. And one last quick reminder before I hand it off to Tim. The reason you want to provide comment is down the road, if you want some legal recourse or you want your voice to be heard on this, providing comment is the best way that you could do this. So the federal government, when they release these public comments and go through this process, part of the process for them is to take every comment, substantial comment seriously through their process. And if you feel they haven't done that, there is some sort of a recourse mechanism. Of course, it involves legalities and whatnot, but you have something there if you do provide comment, some thoughtful comment about why your product should be considered one way or another in this process. So that's a lot from me, but we had last week off, so I had a lot to update the group on. So thanks everyone, or Tim and Matt, for your patience. So looking forward to hearing what you have for the group today, and it's off to you.
Awesome. Thank you so much for that update. So I am Tim Butler, and with me is Matt White. We're lawyers with the law firm of Greenberg, Traurig. People struggle to say that name, Greenberg Traurig, so we generally say GT because GT is easy to say. We're going to make a few remarks about Made in America claims and recent activity at the federal level focused on Made in America claims that you might want to be aware of. Um, but we're going to keep this short. We've got 15 minutes. Just a little bit about GT. If you don't know, we're a law firm. We state on our website we're 3,100 lawyers. We're actually closer to about 3,600 lawyers now. We stated on our website there were like 51 offices. We're actually probably closer to 56 right now because we keep opening them up right and left. Part of the value proposition of GT is that we have experts in almost every area of legal inquiry. So if you have something legal in your realm, you think I should consult a lawyer, GT probably has a resident expert who can assist you in addressing whatever question it is that has popped into your realm. And we do that efficiently, effectively, with the goal of helping our clients thrive. One of the particular joys that I have is partnering with my clients and in their in-house contacts and sort of aiming to come alongside them, understand their businesses, and help them thrive, taking on the laboring work that many in-house counsel don't want to manage themselves. I love it. By way of background, I started out my practice out west. I went to law school in Silicon Valley, and I clerked on the Fifth Circuit. Spent a lot of time at Quinn Emanuel, where I represented tech companies in significant litigation matters before I entered government service. I was at the Federal Trade Commission for a while, which is very relevant to what we're going to be talking about today. And then I was called by Georgia's Attorney General and asked to join the Georgia Attorney General's office, where I was counsel to the Attorney General and helped the Attorney General with significant legislative efforts and also with significant consumer protection matters. That is to say, the consumer protection matters that the AG was most interested in once they'd risen to his desk, so to speak. After being in that role for a while, I returned to private practice. Day in and day out, I help companies comply with regulatory obligations, data privacy and security, payments and fintech related regulatory issues, and advertising and marketing related issues. I also help them when they're being investigated by government agencies like the CFPB, Federal Trade Commission, or the state attorney generals. And then I assist them when they're pulled into intensive litigation where those regulatory inquiries matter. Matt, you want to introduce yourself quickly?
Yeah, hey everyone. My name is Matt White. I'm a senior associate in GT's Atlanta office. I work closely with Tim Butler on basically everything he just said. I have a strong background working with payments companies, handle their complex compliance issues. I work closely with Tim also on to help manage government investigations from the FTC, state attorney generals, you name it. And so, like Tim said, we like to help our clients thrive. We take on the difficult, we try to make it easy. So,
awesome. That's us. I will say one of the things that I like about what I do is I get to work with Matt. One of the joys of my team is that I bring in talented lawyers and I get to watch them thrive. Matt is a particularly talented lawyer. One of the greatest risks of my practice is that my clients sometimes love Matt more than they love me. But I take that as a compliment. It means he's thriving within the firm. What are we going to talk about today? We're going to talk about made in the USA origin claims and about recent activity related to those types of claims. But I want to sort of start by speaking about the federal consumer protection enforcement landscape. And you've probably read, as you follow the Trump administration and what's happening at the federal level, you've read about what's happening at the CFPB, at the Federal Trade Commission, and you've probably also read a bit about what's happening in state AG's offices across the country. There is a sentiment among many companies that the federal government has essentially shut down its consumer protection activity. And they focused that sentiment on what's happening at the Consumer Financial Protection Bureau, where the acting director regularly makes comments suggesting that he doesn't think the agency that he's leading, the Consumer Financial Protection Bureau, should even exist. And it is absolutely true that we see much less activity out of the CFPB now than we did during the Biden administration. That many of the investigations that were brought by the CFPB had been shut down prematurely, before any firm action was taken. And I think that's leading many clients, many companies to believe that they have nothing to worry about at the federal level. But while the CFPB has slowed, other agencies have not. And in particular, the Federal Trade Commission continues to be impressively active. And there are certain types of claims that the FTC is focused on right now, where the risk of enforcement actions is actually heightened versus the Biden administration's tenure. And so you should be aware that the Federal Trade Commission is not shut down. and that they're actually incredibly active. And the headline here, they're still very focused on made in USA and country of origin like claims. You should also be aware that the state attorney generals are increasingly active. 20 years ago, state AGs were sleepy backwaters that didn't actually do much. Right now, state attorney generals they're trying to earn headlines by pushing aggressively in the consumer protection space. So the novel legal theories that we've seen come out of, for instance, Rohit Chopra when he led at the CFPB or when he was involved as a commissioner at the FTC, are being pushed by Republican and Democrat attorney generals across the country in incredibly aggressive ways. So you should just be aware that there's an active enforcement community at both the federal level, primarily focused at the FTC for consumer protection issues, and definitely at the state level. They're keeping me and my team and teams like mine across law firms incredibly busy. What does that mean for you? It means that you should think about that ounce of prevention. So if you're involved with a company that's making advertising marketing claims, in particular with respect to our conversation today, you should make sure that you're doing so in a way that's compliant with existing law so as to avoid an FTC or state AG enforcement action. I promise you they're paying attention. That's the high level overview of the enforcement landscape relevant to made in the USA and country of origin claims. Matt?
Thanks, Tim. Okay, so now let's jump into talking about made in the USA.
One more comment. One of the things we're seeing in the legal world is that associates are using AI to develop their presentations, which means the little images are way more awesome than they used to be. So pay attention. You're going to get some interesting ones as we move through. With that, take it away. Take it away.
Yeah, the last one I asked AI to make an Americana themed, image with a billboard with our message, and that's what it came up with. It's pretty great. There are a few more. So okay, so jumping into the topic du jour, the Made in America claim. So a recent development that is key here, a major recent development, is Executive Order 14392. President Trump signed that on March 13th, 2026. So this executive order, I'll say EO, is important because it makes false Made in America claims an express enforcement priority. Okay, but it's really important here that we understand that the order also doesn't do a few things. It does not rewrite the FTC's legal standard. It doesn't create a brand new definition of what Made in America means when we are assessing these kind of claims. Instead, it tells the FTC and other agencies to focus enforcement, on the rules that already exist and to consider promulgating some new rules to fill in gaps the administration, is concerned that exist. And so first, it directs the FTC to prioritize enforcement actions against companies that make false U.S. origin claims. So if a seller says made in America, made in the USA, built in America, uses similar language, the FTC is being told to look closely whether that claim is accurate and, important here, substantiated. Okay. Second, the order focuses on online marketplaces. Okay, so this is a big deal. The FTC is directed to consider proposed regulations. So consider putting out a notice of proposed rulemaking, providing that an online marketplace's failure to establish procedures for verifying country of origin claims may itself be what we call in the industry an unfair or deceptive act or practice, which is a key term you'll hear when we talk about enforcement in this context. That moves the issue beyond individual manufacturers and sellers, and it potentially puts platforms in the compliance conversation and therefore risk as well. All right, move to the last 2 points we're going to cover on the order. So third, the order directs the FTC and other agencies with country of origin labeling authority to promote voluntary and accurate U.S. origin labeling for products made in the U.S. And then fourth here, if you're working with the federal government in the procurement space, it directs federal agencies overseeing government-wide acquisition contracts to review and verify domestic origin claims for products sold to the federal government. That means there's a procurement angle for government contractors. Inaccurate origin claims may not only mean FTC risk, but it also could potentially lead to False Claims Act type risk. Okay. All right. So we talked about the Made in America rule, and this is what the FTC's focus on. But what is the rule? All right. The starting point is Section 5 of the FTC Act. You heard me say a few seconds ago, I mentioned the phrase unfair and deceptive acts or practices. Well, that's what Section 5 prohibits. It prohibits unfair, deceptive acts or practices in or affecting commerce. So in this context here, the FTC is going to treat inaccurate U.S. origin claims as potentially deceptive advertising claims. In 2021, the FTC promulgated the Made in the USA labeling rule as codified 16 CFR Part 323. If you want to go look, the core standard, one of the things that rule set in stone and codified, is the all or virtually all standard. So for a company to make an unqualified Made in the USA claim, we'll talk about that in a second. 3 things need to be true. So first, the assembly or processing must occur in the United States. Second, all significant processing that goes into the product must occur in the United States. And third, all or virtually all ingredients or components of the products must be made and sourced in the US. It's a demanding standard. It's not enough that the last step happens here. It's not enough that the company is American. It's not enough that the product is designed in the United States. And it's not necessarily enough that the product is assembled here. If the components are imported. For an unqualified claim, the FTC expects the product to be essentially all domestic. Okay. All right. So if we break this down just a little bit, I talked about unqualified claims a second ago. The scope of the rule applies to unqualified claims, okay, that are express, or implied that a product or service, component or part is of U.S. origin. So what is an unqualified claim? Okay, that is a claim without limitations, without caveats. So for example, made in America, made in USA, right? Those claims communicate to consumers the product is essentially American made, and therefore they trigger the full, all or virtually all standard. The consumer thinks this is made in America. There's no thought in the back of their mind that, parts of this came from somewhere else. A qualified claim is a little bit different. It gives consumers more context. So for example, made in America with imported parts or assembled in the US from domestic and imported components. Those claims may be permissible, but only if the qualification is clear, conspicuous, accurate, and not contradicted by the overall net impression of the advertising. So if this is a little disclaimer that, I have assembled in the USA from, imported components, and the overall impression the consumer gets is that it's actually made in America, you could potentially have issues under the labeling rule. And so one thing to think about here too, I just touched on this, is that the FTC looks at both express and implied claims. So a company doesn't necessarily need to use the exact words made in the USA to create risk. If they're using patriotic imagery, American flags, all American branding, things of that sort, it can contribute to an overall net impression that the product is US made and trigger risk of inquiry from the FTC. Substantiation is really important here. A company needs competent, reliable evidence before making the claim. And so you shouldn't rely on assumptions, supplier optimism, or general knowledge about the supply chain. You should document. If you're going to make a made in the U.S. claim, you need to document, your substantiation for that. So bills of materials, supplier certifications, things that sort of things you should be thinking about as you are substantiating your marketing claims. And so one thing also really important to hold in mind here is that while the Made in the USA labeling rule focuses on unqualified claims, if you make qualified claims and those are still, arguably deceptive, you could face risk under Section 5 of the FTC Act for unfair deceptive acts or practices. And as Tim touched on earlier, state AGs look at this sort of thing too. All right, and so President Trump in March signed an executive order focusing and saying this is an enforcement priority, for my administration. A month and I believe 2 days later, the FTC announced a Made in the USA sweep. Okay, and so the timing of this announcement is important because it was probably aimed to show that the executive order was not just symbolic; they mean business here. The sweep involved kind of roughly 3 categories of products. Each one illustrates a different compliance lesson that we'll touch on here quickly. So first, the FTC settled with the seller of electronic dashboards. The issue is that the final assembly occurred in the U.S., but products allegedly included components essentially the function and the operation of the product, like the chips, the electronic screens, and that sort. And that was an issue there. The lesson here is kind of simple. Domestic assembly alone does not automatically support an unqualified Made in the USA claim. If an important or essential component is foreign made, your claim can be deceptive. The second company we're going to touch on here briefly was a footwear company. The company allegedly advertised the products were handcrafted 100% in the United States, and that the entire product was made in the US from heel to toe, using no pre-assembled components from overseas. And then I like this one, that the footwear products were more than made in the USA. But in practice, the FTC alleged that the foreign factories at times manufactured components or handled final product assembly. And so a lesson here is that supply chains need to be monitored continuously, because what happened is like the company had I think due to supply constraints, they had a shift over time. They had to change things temporarily, and their practices changed. And so their substantiation, fell apart, is what was alleged, and they face issues with these claims. And then quickly, the third company we're looking at, the FTC settled with sellers of American flag display products. The companies allegedly use phrases like "built by Americans for Americans," "American made tough," and that was a problem because there were foreign components. And so, a lesson here is that patriotic marketing can be risky if it creates an implied origin claim that the company could not substantiate. So, across all those examples, we see a theme here. Regulators want to look beyond the marketing language. They want to examine the actual product, your components, the supply chain, and how can you substantiate what you're saying. Right. Tim?
Awesome. So incredibly helpful, Matt, incredibly informative. So what's happening here, and I'm just going to put this in like real world terms. If we're focused on made in the USA claims. I do a lot more than made in the USA claims. I do a lot more than made in the USA claims. But the reason made in the USA claims should be prominent in your mind is there probably is no type of advertising that is going to receive more scrutiny than made in the USA claims right now. Country of origin claims matter a lot. If you think about the Trump administration, if you think about who Donald Trump is and what he cares about and what the MAGA movement cares about, this is the kind of thing that is like catnip to these guys. They care a lot about this. So if you're doing anything with respect to made in the USA claims, you should expect additional scrutiny. You should expect heightened scrutiny with respect to that type of advertising marketing activity, because I can promise you the FTC would love to push up more made in the USA enforcement actions, made in the USA related settlements. It is something that they're impressively focused on. The executive order and the sweep were just a signal that this is what they're focused on. But I can promise you that they have teams that are monitoring advertising and marketing on their internet and otherwise to try to find additional cases in this space. For your part, like if you're doing this, I think it makes sense for you to reach out to somebody like me, maybe have existing counsel, but if not, someone like me who can help you make sure that the Made in the USA advertising claims that are associated with your business comply with applicable law, reduce the risk. Generally speaking, we're able to work with clients and enable them to effectively advertise and market their products, but in a compliant way such that the risk is taken off the table. Beyond that, if you've received an inquiry from a government agency where they're asking you questions or seeking documents or information from you, let me promise you that you need competent counsel to treat that investigation not as a discovery exercise where you just produce documents and information, but instead as what it is, a likely enforcement action where you need competent counsel to accurately and persuasively tell your story and so reduce the risk of a company-altering settlement demand. Matt, anything else on that?
We did receive a question in the chat too before we end here. Ryan Harris said, "It is nearly impossible to build an electronic product with any significant functionality that meets these requirements. Is there any way to address that?"
So the administration's position would be that, that may be true, but that should probably also mean that you don't make unqualified made in the USA claims. And this gets very granular. When we advise companies on made in the USA claims, we really dig in on like where all the component parts coming from, where they assemble, where's final assembly, the percentage of the total product that's actually sort of manufactured in the United States. But it's going to be very hard to advertise an electronic device as made in the USA because of the component sourcing issues that are prominent in that space. Any other questions?
I think we're almost at time, and before Christine closes, I just want to say this is so great, Tim and Matt, and appreciate you coming and talking about this topic, because especially at the early onset of the tariff situation and all the volatility, a lot of brands were looking at this topic and saying, my consumer base is primarily in the USA. I'm just going to lean into this type of advertising. So this presentation is so informative to say, be careful about how you message it and what you're saying when you say it if you're going to go down that path. And so hopefully this is something we can share out when we hear that that can help companies from hitting that tripwire. So just want to say thank you so much.
Absolutely. Happy to help. And like I said, our goal is to help our clients thrive, and we'd love to help out anybody we can. Uh, I think you guys are going to send out the presentation. It has our contact information. We'd love to hear from you. If you have little questions, we can just handle those via an email or a call. If you have bigger issues, we're happy to jump in and do what we need to do to protect your business.
Awesome. Well, thank you, Ben, Tim, and Matt, for taking the time to speak to us today. And thank you to everyone who tuned in this week. If anyone has any questions, please email us or feel free to visit our website to learn more about upcoming events. And we look forward to seeing you in about 2 weeks.